DUI Guide Chapter 5, Defenses that Lawyers Use to Fight Your Case. Generally, and we get this all the time, clients say, well, what defenses can lawyers use to fight your DUI charges? Now, the Crown, they need to prove the DUI charges against you beyond a reasonable doubt, and your lawyer's job is to introduce that reasonable doubt. So here are some of the defenses generally that lawyers use to fight DUI charges. First are charter issues. Now, the Charter of Rights and Freedoms protects you against the police and the Crown's actions. And the charter issues are really used a lot by lawyers to defend against DUI charges. And in just a minute or two, I'm going to talk about that in some detail. The next group or bucket of defenses are technical issues. And DUI charges are very technical by nature. So for example, when you're charged with an over 80, that means a breathalyzer machine had a reading greater than 80 milligrams of alcohol per 100 milliliters of your blood. And there may be technical issues with the device. For example, maybe the machine did not function properly, or someone did not properly maintain the device. Those are technical defenses. And lastly, there are a bucket of defenses called evidence to the contrary. In other words, your lawyer may find evidence that contradicts the DUI charges that you're facing. So for example, with a refused breathalyzer charge, there may be a valid medical reason that you could not take the test or why you did not blow properly into the device. So for example, if you had a cold or you had some respiratory issue, that evidence may be enough to raise reasonable doubt to beat your DUI charge. That brings up the issue of, can you get a DUI charge withdrawn? And the answer is, it's possible. Now, the Crown, which is the lawyer representing Canada's government and is the lawyer responsible for prosecuting your DUI charge, they can only proceed with the charges against you based on passing two tests. Now, test number one is it in the public interest to pursue the DUI charges against you? Now, the Crown, they act on guidelines from the Attorney General of Canada. From a public policy perspective, the Crown really, they don't have much of a choice. They're really compelled to pursue the prosecution of DUI charges because doing this really sends a message to the public, to society, that we as a society are not going to accept people driving under the influence of alcohol or drugs. But then there's the second test. The Crown must ask, is there a reasonable prospect of a conviction? And the Crown legally, they could only pursue the charges against you if there is a reasonable prospect of conviction. Now, it's your lawyer's job to raise doubt in the case against you. If those doubts rise to the level where there would be no reasonable prospect of a conviction, then yes, the DUI charges against you would get withdrawn. Now, if the DUI charges against you, let's say it's your first charge and you really have an impeccable background, will the DUI charges against you get withdrawn? And the answer is no. The fact that you've never been charged before does not matter. The fact that you're an outstanding citizen does not matter. The only way DUI charges against you would be withdrawn is in the event there are significant problems in the Crown's case, and these significant problems are so severe that there is no reasonable prospect of a conviction, and only then would the DUI charges against you get withdrawn, but they have no relation to the fact that you've never had this charge before or that you have an impeccable reputation.